see, again, state code under Title 4, the same title we've been discussing, Title 3, in fact, does define Title
Title
3,
III.
2103 does list Lander City Police Department as a municipal law enforcement agency, just for record's sake. But that was the point we were making, is that this court, yes, can review the matter and the arguments contained therein, but that the statutory language is completely and unquestionably clear.
Would the political subdivision in question, because you make reference to 2103 just now, would it necessarily require that a particular city government has to be established and that it is in full fact and force, and that its authority has been delegated under the Home Rule?
As a matter of law, Your Honor, is that a question, or were you just opining?
I'm asking a question. Does the law require that for a political subdivision to exist, or let alone something to be considered a political subdivision, that there be a functional government for that particular?
That's a great question. My co-counsel, I believe, is double checking that now. I have read the entirety of the state code, and
you haven't prepared this argument. I thought you mentioned 2103, and I thought you would have had this prepared in advance. This would have been a question expected.
I'm just going to read 2202, just a ways down from 2103. Quote, a municipal law enforcement agency shall employ no more than 120 employees if their jurisdiction resides within the city of Lander. The jurisdiction of the aforementioned agency resides within the city of Lander or any otherwise incorporated municipality where the Senate chooses to convene to do business.
Consider 2202 AI, that's repealed. That's the language that I cannot factor in.
Correct. I was continuing to read on, but again, in answer to your exact question, oh, perfect. My counsel found it. So Title 3, MSC 1, 2103A, quote, the term municipal law enforcement agency shall refer to, quote, any government agency within the jurisdiction of a municipal political subdivision that enforces the law. In response to your question about a political subdivision, we cannot find a specific statutory definition of a political subdivision. What we can say is that what is repeated throughout the state code, disregard one more time, my counsel found additional information. 3 MSC 1 6101 subparagraph A. The term political subdivision shall refer to, quote, regional jurisdictions generally include, but are not limited to, the state, county, or municipal governments residing within the boundaries of the state of Mayflower. So I think there is a clear statutory language and vision that is painted for the court. If they want to say, for example, why then wasn't 1101, the statute regarding a jurisdiction for Lander, why wasn't in a special section for an act regarding the city of Lander? Well, for one, there is no Lander city government, but a political subdivision does exist. It is the city of Lander. The court, I mean, this is common law knowledge. This is well established that the city of Lander does exist. Otherwise, why does the Lander City Police Department
exist? The city of Lander government exists?
I said the City of Lander Police Department does not exist. I said, but the very fact
wait, I'm sorry. I misunderstood completely. I think I lost my train. I lost my trail here, because you've just said that the City of Lander Police Department does not exist. I think you might have I don't think you were trying to actually say that.
I said, so the city of Lander, as it relates to a government entity, you referred to why then would we interpret 1101 without there being an actual political subdivision, i.e. a city government. There is no current Lander city government. That is by design of game administration, something we cannot litigate. What I will say is that the fact of the matter is that there is a municipality defined as the confines of the city of Lander. The city of Lander does in fact exist. This is well established law. I won't insult the court's intelligence by trying to argue that. The court obviously accepts that the city of Lander exists. And by default, the Lander City Police Department also exists, and that is a matter of statutory and well-established law in the state of Mayflower. So those two elements are 100% present. For one to argue as it relates to a political subdivision or a municipality, well, the city of Lander is considered by law a municipality, and the Lander City Police Department is considered a municipal police department. I think the overwhelming statutory language, regardless of how or where it is located in the state code, it is concisely establishes and creates the understanding that the city of Lander exists and that there is a definite jurisdiction of the city of Lander. But again,
Um,
we've spent a significant amount of time, so I don't want to waste the court's time. So
I get to determine whether we touch on a particular issue or not, and I understand that we are particularly strained for time. But if we have to drag on for however much time we want to, then I will do it because these are all very important issues. And I like to make sure that I am firm in any decision I make for this particular issue. I know it's very sensitive, it has a lot of attention by the media, among other things. So I'd like to be absolutely certain that the decisions I make here will be sufficient enough for the scrutiny from this court and from other courts, and also by other legal experts. But I'd just like to make it very. I just like to ask, in particular, would if the City of Lander Police Department does exist, are we just assuming that the City of Lander government exists, even though they have not physically been formed? No physical formation of it has been made. There is even no written law in particular that would grant the city government any particular powers thus far to govern itself or anything like that. There is absolutely nothing I can see where the city government does actually exist in any form other than references to it in state law. And in that case, would it not be fair to say that if that city government does not exist, their authority kind of really stems from the state? And in that case, the jurisdiction argument that you raised may be fake, to put it politely, because I'm going to bring attention to that. Could be a potential scenario, and I'd like to hear some reassurances that I'm wrong or anything along those lines. If you want to clarify, I'm more than happy to, but Mr. Pancakes? Hello? Did something happen?
I can hear you.
Mr. Oh, hi. I'm not sure what happened to Mr. Pancakes here.
Maybe it was too much for him.
Yeah.
The government would like to say something about jurisdiction.
For the time being, I'd like to try and maybe get Miss Boppy to fill in. I know it might be a little bit inappropriate, just like to make sure that we kind of touch on some other points. Mr. Dogachu, would you mind if I ask Miss Boppy to maybe speak?
Oh no, Your Honor. Go ahead.
Okay, thank you, Miss Boppy, or Lieutenant Boppy. Sorry.
Yes, Your Honor.
Would you like to perhaps talk about point 1 while Mr. Pancakes is recovering from some technical issues? I think we are aware that he probably does have a technical issue right now. So.
Yes, absolutely. I was just in
Okay.
contact with him. He is trying to reconnect, but I will absolutely
Okay.
address point number 1. So in point number 1, Your Honor, we focus primarily on the rules of criminal procedure. And it, like I said in the opening, it really outlines very few circumstances where arrest warrants can be or should be issued by a court. And we obviously are on the belief that none of these circumstances exist here for the issuance of this arrest warrant. And quite frankly, arrest warrants do have these sort of boundaries to them because they aren't tools that should be used to kind of circumvent the power of the Department of Justice to choose whether or not to prosecute somebody.
So you're saying that the arrest warrant is an instrument against the state's own power to prosecute. That seems really weird to me. You know why? Because arrest warrants are usually filed by, people who are working for the government, who are enforcing the laws. And if this somehow was used as an instrument against the enforcers of the law, does that make any sense to you? I don't. It's hard for me to even say it. This sounds bizarre to me, what you've just said. That the police filing an affidavit to get an arrest warrant that somehow contradicts the interest of the state to prosecute. Does that make any sense to you at all? Does that sound right to you? Because I don't think that sounds right to me at all. Because whenever people file affidavits, they usually cooperate with the prosecutors. Otherwise, prosecutors decide, after the warrant's been served or what have you, even before then, they'll have some level of involvement, some review as to the way that the police have handled it, or the charges themselves, the nature of them, and the events surrounding them, and they'll usually litigate it sometime later into the process, not now. I'm struggling to understand what you've just said there. You're also representing Mr. Tom, who's affected by this. You're not speaking for the government, are you?
No, we are representing Tom.
Right.
Yes. So I'm not going to speak behalf on the government. The government is here and can talk themselves. I was just commenting on the controversy that you had mentioned that can't really be ignored in this case. But nonetheless, even kind of absent that, this warrant still does not comply with Rule 2 of the criminal procedure because, again, there were no exigent circumstances present. There is no risk to public safety. There is no risk to evidence. There is no now or never situation, especially since this was filed 3 days after the incident actually occurred. And again, there's no LTA. There's no evasion of law enforcement. So that gets rid of already one of the requirements to getting an arrest warrant. And second of all, the Department of Justice, as we have been tracking, has not filed any criminal information or filed anything in a court that would justify getting an arrest warrant on Tom.
Do they have to file that information in order to be able to action a warrant? Could officers not file affidavits, seek a warrant, get the warrant, and then the DOJ can still determine the situation after the warrant's been served at a later time? Could they not do that? Is it not available to police officers to ask the courts to to get a particular warrant issued against a person because they committed a crime or whatnot, or otherwise suspected of committing a crime? Is that not? Wait, is that what you're trying to say? I don't understand this at all.
Your
I'm
Honor,
very confused.
Yes, I'm quoting directly from Rule 2, and Rule 2 very plainly lies out again these two circumstances. And one of the circumstances says, or in connection with a filed criminal indictment or information. And there is no suggestion here that law enforcement can get arrest warrants absent this procedure.
Well, I'd just like to make point on the first set of languages, and obviously it's not kind of directly addressing your argument, but I just like to make a good mention of it, that the overarching theme about this rule is that law enforcement officers have the ability to apply for warrants, and they're not debilitated from it. I think we like to. I think it's safe to say that we all agree on that. Rule 2 does allow them to be able to do that. As to the conditions for it is the issue that we're disputing here. And I see what point you are making as to the exigent circumstances, but I feel like you're really relying on the fact that they've waited 3 days before filing an affidavit. Seems completely bizarre to me. And your complete reliance on that seems troubling, because if I'm misunderstanding the legal standard for it, and happy to correct me if you wish, but I believe that exigent circumstances doesn't mean, that they would necessarily be there would no longer be an exigent circumstance because it's been some time and they decided not to. Even if they investigate it, it becomes futile because it's no longer a huge emergency or whatnot. The whole thing about it taking 3 days seems bizarre. They were investigating, as far as I'm concerned, and according to that affidavit, that they had investigated the whole situation. If, by your logic, that we would say that an affidavit or an arrest warrant is invalid because they took 3 days, which I assume they were probably investigating, well, likely not, they will state that they're investigating, then they would have to file an arrest warrant only if, indeed, the incident happened on the same day at the very minute and second, and somehow they can't catch the guy, so they have to call us on the phone or whatever and be like, hey, judge, can I get a warrant? That doesn't make any sense, does it? I don't know. I think this is a little bizarre, and I might be misunderstanding this wholly. I may not be the most smart person here, but I think it's a bizarre argument to make that an officer is expected to somehow sort this all out in 1 day or 1 second or 1 millisecond, simply because, simply because that's, by your logic, that's how it should be. The 3 day thing is a little bizarre to me, and I've also had a read as to the fact that he was suppressed or whatnot. I believe killed, was it? He was shot and killed. Was that what you submitted? He was killed, and the result of that, there was no exigent circumstance? Is that what you
No.
said in your... No.
No,
What was
I
it?
did say that the video that was uploaded with the affidavit does show that he was shot after firing the shots. And Your Honor, the 3-day time period that I keep referencing, that is just part of the analysis for determining whether exigent circumstances exist. Based on a brief glance at case law, for exigent circumstances to sort of apply to the arrest warrant realm kind of seems a little bit unique to this game, because usually exigent circumstances relate to whether a law enforcement can do search and seizure. And so historically, when courts have been analyzing this exigent circumstance standard, they are looking at a now or never moment because there has to be some reason, some pressing, concerning matter that kind of allows them to go around the normal venues, perhaps a DOJ investigation or criminal indictment. And so when I'm pointing that out here, Your Honor, I'm just trying to prove that this was not something that was immediately required given the circumstances. Again, there was a lengthy period of time. There was no threats to the public safety, no threats to the officers' lives, nothing of the sort that the affidavit
There
had
was no
pointed
threat
out.
to the public safety? There
No, the
wasn't?
affidavit did not point out the threat to the public safety. And again, Your Honor, I don't want to come up here and make rash or sort of conclusions, legal conclusions based on this motion to quash. Right now, we are relying on what the affidavit had submitted.
Right.
Oh, 1 second, Your Honor. I think Tactical Pancakes needs to be brought back up to the stage.
I am trying to get him back, and I can't. I already requested him to be here, so he should be able to see it. I'm a little confused by what you've just said. What in the world? Sorry, I'm very lost by what you just said. Exigent circumstances don't exist because what on earth? What?
You're on.
Let's get back to this later. I think we're just going into some weird circular argument.
No, if you have any questions, I have no problem clarifying any confusion.
No, I'm just disturbed by what I'm hearing. I'd like to maybe get a little more time to think about that later. Perhaps we could go on to the other points about how this might be a procedural defect. because of the leave to avoid arrest. That's what you mentioned earlier as well.
Yes, because again, this is what is outlined in the rules, Your Honor.
Yes, so you're saying that he hasn't actually... Hello, Mr. Pancakes. I'd like to have Bobby continue the argument here for the time being. We'll get back to you later here. Oh, actually after this, but hold on for a moment, Mr. Pancakes. So you're saying that he has not left to avoid arrest at all, at any point?
No, Your Honor. No attempts based on the affidavit were made to arrest the original Tom Sheriff.
Right.
In these events.
Right. Okay. Okay. I'd like to make mention that in game there are particular people, usually those on a particular team, privileged of not being able to be physically restrained in any way, shape, or form. Otherwise, not really required to subject themselves to any form of arrest process whatsoever, unless they choose to. Are you saying that the leaving to avoid arrest condition is solely reliant on the fact that they have to physically leave the game in order for that condition to have been triggered? I just like you to clarify that.
No, the rules do. This rule says has left the immediate presence of law enforcement officers. So I'm assuming that could be evasion, or that could also be leaving the game physically.
Right. Okay.
Your Honor, can I make a point real quick, please?
Sure.
It sounds like the court is focused on elements of what the rules and relevant statutes and case law as they relate to what defines leaving to avoid arrest. And if that is the case, I would offer this is actually...
I've only just touched on this now.
Correct. Yeah. I'm sorry. I had a disconnection issue, so
that's fine.
Forgive me for that. The
That's
question
fine.
I would pose is that no effort was made directly following this encounter